Fantastic. So I'm now recording this. If you don't want to be, on the screen, please turn off your cameras. But I hope some of you keep your cameras on so I can see your faces and your reactions. Okay, so as I said, the crux of crim immigration is that a criminal conviction can affect an individual's immigration status for all non-citizens, and that includes people who have their green card, so are lawful permanent residents. Despite the word permanent in there, you still can be deported for criminal convictions. And also it affects individuals who are here through COFA. Those are two common questions I get. What are common misconceptions about how criminal conviction can affect your immigration status? Well, these are five questions I get often. What if it's just a misdemeanor? What if I took a plea deal? What if I pled no contest instead of guilty? What if I got a deferred acceptance of a no contest plea? And so so I was told that my conviction is going to go away after a while. What if I got probation, like no prison time? It was so minor. Well, that doesn't necessarily mean that you won't be deported or you won't have immigration consequences. It might still be a problem. And the reason why Crim-Imm law can be quite complicated is that immigration law is different from state criminal law in ways that are sometimes unintuitive. So I won't go into the history here, but criminal immigration is really about a century of weaving together criminal and immigration law, and in ways that are still changing today and change all the time. And that kind of helps, I think, it helps us to remember that as we go into the law and as we encounter things that seem unintuitive, perhaps to common sense. This chart is not something for you to memorize. It's to show kind of a question that I get often is, well, how does immigration even find me if I, encounter the police or have a criminal case or just get arrested, but maybe I'm not even charged? There are a lot of points of entry into the immigration system from the criminal system. And this chart just gives an example. Everywhere from the arrest or just the police stop, not even arrest, to the period of incarceration, there's a lot of entry points and data sharing and information sharing that can lead immigration to find you at your door. And even after you're done with your criminal justice experience, years later, perhaps you're returning from a trip from abroad or applying for an immigration benefit, and then immigration missed you before, but realizes that you have a criminal conviction, and then ICE, being the immigration authority, will arrest individuals. So these are really, really important issues to understand because they can really follow your immigrant clients throughout their lives. So again, jumping backward, now that I've kind of given an introduction of what we're talking about and why it's so important, Immigration 101. I want to just go through some key terms and players so that we're on the same page. So what are the agencies we're talking about? I'm going to be using a lot of these terms. The big agency over in DC that handles immigration is the Department of Homeland Security, or DHS. Under DHS, there are three sub-agencies. The top one is ICE. The top one is USCIS, I have here. And that's kind of they like to brand themselves as the customer service branch of immigration, or at least they used to. And so that's where you submit your applications for naturalization, or to bring a family member over, or to get a work permit. And they basically handle your affirmative applications, we call it. The second one, Customs and Border Protection, they're the ones who patrol the southern and northern borders on the continent. They're also the ones that sit in the airport and stamp your passport and let you in, whether you're a citizen or a non-citizen. And they come into play mostly for new immigrants, people who just arrived. And then we also have ICE, Immigration and Customs Enforcement. And these are kind of the main players that we're going to be dealing with in crim immigration. They're the ones who arrest somebody for an immigration, what they allege is an immigration violation. They're the ones who prosecute immigrants in immigration court, prosecute meaning try to deport them. And so they're the main people that I'm going to talk about when I say immigration arrests you or immigration tries to deport you. You may also see the Immigration Naturalization Service, or INS. That's the agency that used to handle immigration and then was replaced by DHS in 2002. You'll still see that name though, because of a poor copy and paste job or a really old law. So just know it means DHS. And then Department of Justice, DOJ, headed by the Attorney General, they're the ones that handle immigration court. And the specific sub-agency that handles immigration court is EOIR, or the Executive Office of Immigration Review. So going from there, what exactly is the procedure? So when someone is in immigration court in deportation proceedings, the government's trying to deport them, they start in immigration court down here. And then whatever side loses, either the government or the immigrant, also called the respondent, they are able to appeal to the Board of Immigration Appeals. Now, both of this, as I mentioned, these courts are under the DOJ. They are not Article 3 courts. They're courts under the executive branch, Article 1. And then if you lose at the BIA, you can appeal once again. And then you hit the Article 3 courts, the federal judges, and you appeal to the Court of Appeal. So here, Ninth Circuit. And you skip the district court. And that makes a difference as you're looking at research. So the federal district court, District of Hawaii, for example, that's completely skipped. It goes straight from the BIA to the Court of Appeals. And then, of course, you can petition for certiorari at the Supreme Court, and they have the discretion to accept or not. Here, just a side note is that sometimes the Attorney General can ask to be certified a case, and in which case they can review the Board of Immigration Appeals decision, and then that is also good law. And then from there, that can be appealed to the Ninth Circuit. Okay, and then what are the laws we're talking about here? So pretty much everything related to immigration is under the Immigration Nationality Act, or 8 USC. So everything 8 USC, 8 US Code is immigration. Every once in a while, you'll get something in 48 USC when it comes to law of the territories and immigration, but for the most part, we're talking 8. And then case law, we're looking at BIA precedent. So that's, again, the agency precedent, and then Ninth Circuit precedent. And there's some cases in which district court precedent would be relevant, but very, very rarely. And again, we're looking at federal law. And then what is an overview of immigration statuses? Again, this is not something that you need to memorize, but it's helpful to see that there are actually a lot of immigration statuses that we're talking about. So going from my right to the left of the screen, then your most secure status is a US citizen. So if you have a US citizen client, none of what I'm talking about applies. Your citizenship cannot be stripped from you for committing a crime. Then going backwards into the less and less secure status. So secure just means, will I have to leave the country? How secure is my status? Can I stay for a long time? The second most secure status is being green card holder. But again, unless you've become a US citizen, if you're a green card holder, this still applies. Criminal convictions still can get you deported. And then going from there, there are what I call some in-between statuses like asylum, refugee, and then going all the way to undocumented, and then over here these non-immigrant statuses, and then temporary statuses. I have them in quotations because that's what they're legally considered. Of course, we all know that there are people here through COFA status, DACA, TPS, some of the agricultural workers. They are immigrants, they're not non-immigrants. This is their home, they're here to stay. But that's just the term under immigration law. So now getting into what we're talking about. So you'll see the word deportation in the news, and it just, how we mean it colloquially is somebody is forced to be kicked out of the country. It actually means something legally that's a little more specific. So removability is the broad legal term for, kicked out of the country. And then it's categorized to deportability. So you're able to be deported, and then inadmissibility, meaning you're not allowed to enter. And this matters because they're two separate laws and they're very similar, but they're a little different. So again, so deportation means they can kick you out of the US after you've been let in. So this affects people who have been inspected by an immigration official and given permission to enter the US. So that's, if you have a green card, it's deportability that applies to you. If you're a visa holder, even if you're currently undocumented and you're a visa overstay, that applies to you. If you're here through COVID, that applies to you. And here's the statute at issue. Inadmissibility means you're not allowed to enter the US, but there's a bit of a legal fiction going on here in that inadmissibility is still the law that applies to you if you haven't been formally inspected and allowed to enter. So for individuals who are here undocumented and are visa overstays, they entered without permission, that's going to apply to them no matter how long they lived here. It also, relevant to kind of a lot of your practices, it also affects individuals applying to enter the US through COFA. Even if they live here, they own, they rent here, or they own property here, they have jobs here, every single time they re-enter the US, it's considered a whole new admission. And so inadmissibility applies rather than deportability or, just being let in. So that's kind of important to keep in mind as we go into some of the nitty-gritty of the law. And then finally, there is something called forms of relief, meaning even though technically you are inadmissible or deportable because, say, you don't have any papers, you're undocumented, there are still forms of relief, meaning things I can apply for that will let me stay, as well as other immigration benefits. And I bring that up because criminal convictions can factor into all those decisions. So if you have, for example, you're a defender, you have an undocumented client, and it's like, well, whatever criminal conviction they get, they'll be deported anyway. That's not true. There's some, if you get the criminal conviction, then you don't get the relief, what's called the relief. And if you don't have the criminal conviction, even though you're undocumented, perhaps you would have been eligible for this other thing. So it really applies to a lot of things. And again, also for, even if you're not, a criminal conviction won't cause you to be deported, it can affect what's called benefits. Mainly the big thing that people are worried about is, are they going to be able to become a US citizen? Will this affect their ability to naturalize? And oftentimes the answer is yes, or yes for 5 years, yes for a limited time. Okay, I'm going to take a pause there and see if anyone has any questions on Immigration 101. Okay. All right, I think I don't see any chats, but okay. All right, so jumping into the meat of our discussion today, Crim Immigration 101. Okay, so what are removable offenses? I keep saying that you are able to be deported for certain criminal convictions. Well, what are they? The federal law defines them, and they have them in different categories. The biggest category, and the one that causes the most trouble, is called aggravated felony. So I'm going to go down and just click through all of these first. So an aggravated felony sounds really bad, right? It's a felony and it's aggravated, but it's actually, it's kind of a misnomer because it's really an immigration term of art. There are some crimes, murder and rape I have as the first one, that are what you might consider aggravated felony. There are also crimes that are actually quite minor, what the state law might consider quite minor, that also fit within this name. So, and it doesn't matter if the state law considers it a misdemeanor or a felony. So really think of the word aggravated felony as just its own special word that immigration came up with. Don't pay attention to the word felony or aggravated, because I think that'll just confuse the analysis. So the aggravated felony statute lists a bunch of things, and you just kind of have to go into the law. I put the statute down here to see if what it includes. It includes everything from theft fraud, failure to appears in court, and a whole bunch of other things. Getting an aggravated felony is sort of the worst case scenario. It's the thing that makes you ineligible for pretty much every kind of relief. It's the thing that really gets you deported, and deported quickly. In addition to that, there's controlled substance offenses, so drug offenses that match the federal drug statutes. And then I'll just go through the rest of these kind of quickly. A crime of child abuse, crime of domestic violence, firearm offense, and then crime involving moral turpitude, which is more relatively minor compared to aggravated felony, but I'll spend some time in it in Crim Imm 102 because it's the most common thing you see. Because first of all, the law is very confusing, and second, a lot of relatively, what we might consider relatively minor things, are wrapped into this crime involving moral turpitude. And each of these has their own, set of case law. Here's some, I just add a couple bullet points for you to look at later if you're curious, but we won't get into all of it. So now jumping into the doctrine of it all, the reason why there's a whole area of the law devoted to this is that we're talking about state law versus federal law and how to mush them together. Because a criminal conviction is state law, generally. Obviously, there's federal crimes, but we're talking about state law criminal convictions. And then these removable offenses that I just went over, that's all federal law. So the question of the categorical approach is whether or not they match, essentially. So what is the categorical approach? It asks if the state criminal conviction is a removable offense, and it says that it is only if there is a categorical match. In other words, it's not categorically overbroad of the federal generic definition. So that's kind of all like legalese, and I'm going to break it down, but it's just the words categorical match and categorically overbroad are kind of the two key words in this doctrine. Put in another way, does the state statute criminalize conduct not covered by the federal definition? How do these things overlap? And at this point, I think I found it helpful if people kind of understand the history of it a little bit. Categorical approach, it's a doctrine created by the Supreme Court. So it's not like a law that says what the categorical approach is. What happened was Congress said all of these crimes get you deported, but they didn't define the crimes. They didn't say, what is theft? What do we mean when we say burglary? And every single state defines every single crime a little bit differently. And what the Supreme Court was finding was that some states define crimes more broadly than what the federal definition was, what the historical definition was, for example, or what a federal statute that's relevant here defines it as. And the Supreme Court said, okay, well, that's actually not that fair for these immigrants because Congress didn't intend for them to be deported for all these broad ways that, let's say, Oklahoma allows, if you do all these different things, Oklahoma considers that theft. But actually, federally, only this little small number of things is theft. Just using that as an example, I know nothing about Oklahoma law. And so we actually only want to deport people who have committed crimes or convicted under statutes that match the federal definition. If the state law is too broad, it's including all these things that Congress wasn't thinking of, we don't want to deport the person. So I don't know if that's helpful or more confusing, but that's kind of how this doctrine came about. So going into an example, to help illustrate this, let's say we have a state conviction for theft. I want to know if it's an aggravated felony, a theft aggravated felony, which again will get you deported. So the question I ask myself is, does the state statute for theft include conduct that is broader than the federal generic definition for theft? So we got the state statute, we got the federal definition. How do these circles interact with each other? So example one, we have the federal definition is broader than the state statute. So the state statute for theft is super, super specific. You can only get convicted if you do very specific things. Federal definition is broader. Okay, then that is a categorical match. The state statute is not categorically overbroad. The federal one, that's broader. And so that is a removable offense. We do have an aggravated felony. Second example, the two definitions are exactly the same. They're like two circles that are right next to each other. Then yes, it's also a match, and we have ourselves a removable offense. Both of these are theft, aggravated felonies. Aggravated, you also see them as ag-fels for short. And then, so what are examples of things that are categorically overbroad, which means that they're not removable offenses, which means if your client is convicted of them, they will not get deported for this reason. So one example is there is a little overlap, but the state statute includes things that the federal definition doesn't, and the federal definition includes things that the state one doesn't. So, and then the second example is the state statute is just way broader than the federal. The federal, everything under the federal definition, yes, can be subsumed by the state, but the state just includes all these other things. And then the third definition, obviously, if there's no overlap, if there's just two completely different statutes, then there's no aggravated felony. And this person will not get deported for having committed a theft aggravated felony. And then how do we figure out whether or not where these circles are in relation to each other? So what you have to do is look at the elements of the crime. And that for those in the Office of the Public Defender, that's a thing you need to do anyway, because the whole point of the being convicted of a crime is that you're convicted of having done all the elements of the crime. And so how do you do that? You look at statutory interpretation based on the plain language of the statute. So what does the statute actually say? Yes, it's called theft, but what does the actual text of each subsection say? And then you also look at state case law to help you understand what that means. And then you can also look at jury instructions as persuasive, but they're not determinative, meaning even if the jury instructions say a certain thing, that doesn't necessarily mean what the law is. What you're not looking at, and this is really, really critical, what you're not looking at are the facts of the particular case. So you're looking at the statute, and you might be looking at the facts of example state case law cases that the Supreme Court said, okay, so this person, took this, came into the store while it was still open, and at that point that was legal, but then they stayed past the time they hid, and they stayed past the time of closing. Is that burglary? Is that theft? So you can look at those examples, but you're not looking at the facts of the person in front of you. And I think that's why it's in this categorical approach, it's all about the law. It's really not about the specifics of the person, the case, the example that you're dealing with in this moment. So that is the categorical approach in a nutshell. It gets a little more complicated though. And so to help you understand, I'll give a little bit more, broad strokes history. But then people are like, okay, well, that's not fair then actually, because yes, perhaps this law overall is too broad, but actually my client, or not my client, but your client, I'm being the government right now, your client was convicted of subsection A, which clearly is a match to the federal definition. Why should they be let off the hook just because subsection B exists? So this leads to something called the modified categorical approach. And when you're doing research, you have to kind of do this whole thing. So the first step is what I just described, the categorical approach. Second step is divisibility. Is the state statute actually multiple crimes? And the third step, called the modified categorical approach, which I'm going to go into all these bullet points in more detail, but I just want to outline them here on the get-go so you know where I'm headed. Looking at the record of conviction, which is a term of art for a particular set of documents, can you tell which part of the divisible statute the conviction was under? And then finally, does that statute, that subsection, is that broader than the federal definition, or is that a match? So what does divisibility mean? How do you know if it's divisible? Okay, so let's say we have a statute. We've determined that the statute as a whole is broader than the federal definition. The next thing we have to ask ourselves is, okay, then is it divisible, meaning that it's actually two separate crimes? And you can answer that question by seeing if there are actually multiple elements that are involved in each subsection. And the key thing here is we're talking about multiple elements rather than multiple means. So elements are a core part of the crime. The jury, the key thing that the court will ask is, does the jury need to unanimously agree in order to convict someone? And then means are just factual alternatives that do not matter to the conviction. So taking a really, really basic example to illustrate this, let's say it's a crime to steal your siblings' dolls or games. An example of a not divisible statute is that it's a single crime to steal your siblings' toys. Dolls and games are just means to commit the same crime. It doesn't actually matter to your conviction to whether jury convict you if it's a doll or a game that you stole. And then a divisible crime is that it's a separate crime to steal your siblings' dolls and a whole separate crime to steal your siblings' games. And so it does matter to what you're convicted of, depending on if you took a doll or took a game. And then how do you know it's divisible? So again, like I said, the key test is, does the jury need to determine the fact in order to convict? And what are the things you're looking at as you're doing this research and asking this question? So first, it's the language. Looking at that there's different subsections. There's A, there's B, there's C. Disjunctive, using the word or, so saying, the doll or the game. I mean, those are all good clues, but again, it's not determinative. Just because there's the word or just because there's subsections doesn't mean necessarily that's divisible. Another thing to look at is sentencing exposure. So that's a really clear sign. So again, using my kind of dumb example, if mom says, if you steal a doll, you're in timeout for 10 minutes, and if you steal a game, you're in timeout for 15 minutes, that's sentencing exposure. That's a pretty clear sign that there are two different crimes we're talking about, so it is divisible. Looking at jury instructions, again, persuasive but not determinative, and then looking at the state case law, how are courts actually treating the statute. And so let's say it is divisible then we go to step 3, and to see if we can actually figure out if this client, this non-citizen, this defendant was convicted under subsection A or subsection B. Are they convicted of the doll crime or the game crime? And the law says that a judge, a fact finder, the immigration judge, can only look at a limited class of documents in order to figure that out, called the record of conviction. So in other words, they can't go on their own fact-finding mission. They can't, bring in witnesses and say, did you steal the doll or did you steal the game? They have to look at the documents produced through the criminal trial, through the criminal process. And the things under the record of conviction include a charging document to the extent that it's consistent with the final conviction, a written plea agreement or a transcript of a plea colloquy, any factual finding by the trial court to which the defendant assented, jury instructions, and then jury instructions of that particular case, not just general jury instructions, and then anything incorporated into the guilty plea or verdict. And then again, so this record of conviction, it's very confusing. The law is a little unclear at certain points. I'll go into a little bit of a deeper dive on that in Crim Imm 102 if we have time. Critically, the record of conviction will generally not include things like the police reports unless they are actively incorporated into the plea. So, okay, let's say the judge takes a look at all that and says, okay, so it's possible to tell that this person was convicted under subsection A. So they definitely clearly stole a doll, not a game. And then you do the modified categorical approach. Basically, you make that comparison with the federal definition all over again, but with just the subsection that's determined to be the divisible, the part of the divisible statute that you were convicted under. So here's, the visual example. We have the doll, we have the game. The doll is completely under the federal definition. It's not overbroad. So this is kind of considered its own little circle, and the court isn't worried about it. And so in this case, yes, this person would be convicted of an aggravated felony. So here's a summary of it. And this summary, I'm just going step by step to really tease out the process to help us learn it. You know, in real time research, you don't actually necessarily need to go step by step by step. In that, for example, if you find that a statute is overbroad, you do always need to ask if it's divisible. But let's say you already can tell from the get-go that every single subsection is overbroad, every possible way to divide it, it's still going to be overbroad. Then it doesn't matter, because you already know that every subsection is overbroad. You don't have to go through this whole thing, because in every single case, you're going to get back to the answer that it's not a removable offense, because in every case it's overbroad. So that's the kind of mental shortcuts you take when you're really doing research, but this is just really helpful in the beginning as you're still learning the doctrine. So for, you might be asking, what does this mean for defense attorneys? Kind of why have I partnered with the Office of the Public Defender for us to kind of all talk about this, and the partnership that we have kind of advising, talking to each other about these case updates. And it's because it's really important for advising clients. It's a constitutional obligation for defense attorneys to advise their clients. If you don't, it's ineffective assistance of counsel under Supreme Court case called Padilla. And in addition to your constitutional obligation to advise clients so they know what to expect if they're going to be put in deportation proceedings, I also hear from a lot of defense attorneys that it's important to them to, as much as possible, create safer convictions, because you can be really excited to get a really great conviction for somebody, but what might be a great outcome for a citizen ends up not being a great outcome for a non-citizen because they just get deported. That's really obviously really disappointing. And so I love talking to defenders and kind of how they've been creative to kind of come up with these safer convictions. So pleading obviously to safer offenses, being safer meaning fewer immigration consequences, paying attention to the sentences imposed. So for example, a couple of aggravated felonies are only considered aggravated felonies if your sentence is 365 days or more. For example, obstruction of justice aggravated felony or a theft aggravated felony only counts. You only get in trouble if it's the sentence in jail is in prison is 365 days or more. Then also, like I mentioned, keeping that record of conviction clean, meaning, again, because the judge can only look at record conviction when they're talking about the modified categorical approach. So if it's clean, then they can't figure out which subsection your client's convicted under. That's a really powerful way to protect your client. Okay, so let me see, what time is it? Okay, we're doing okay on time. I'm gonna pause there and I'm gonna stop the share so I can see the chat and see your faces, and just, feel free to unmute or raise your hand or put something in the chat if you have a question. Okay, I see a question in the chat. Okay, and then I see a never mind, so I will not read that, but I can if I didn't actually answer the question. So actually that is a very good question. So I'll read it out for those who aren't on, who are on phone. The question is, you listed crimes of child abuse. Does there have to be a familial relationship between the client and the minor victim to constitute child abuse for removability analysis? Is it treated differently if the minor victim and the client are not related, like a charge of assault? So the crime of child abuse kind of has its own set of doctrine associated with it. It does not necessarily have to be. So the Hawaii law actually defines what is crime of what domestic relationship you need to have in order to be convicted of certain family law crimes, and they do match. So the federal law looks at that, and we'll look at the record of conviction to tell if you can tell it's a minor victim. So one thing, record of conviction we always advise is keeping the age of the victim if it's a minor, keeping that relationship out of the record of conviction if possible. And so the court kind of does look at different. If it's just a charge of general assault, they might not look that deeply, but there is a possibility, but it's more rare. So it's really just kind of these family law crimes of domestic violence that we're talking about. But yeah, it kind of has its own doctrine as well. But that's it in a nutshell. Any other questions? Okay, I'm gonna then, since we do have time, jump into Crim Imm 102 and do a slightly deeper dive into two parts of the law that are particularly confusing. So that record of conviction, what is the record of conviction? Again, it's a limited class of documents that may be reviewed. And when I say reviewed, I mean reviewed by the immigration judge, who again is deciding whether or not to deport your client. So the charging document is a big thing, but again, only if it's consistent with the final conviction, the written plea agreement or plea colloquy transcript, any factual finding by the trial court to which the defendant assented, jury instructions, and anything incorporated into the guilty plea or verdict. And again, not police reports unless they are incorporated. So the question I always get then is, what does it mean to be incorporated? Is this police report incorporated? It's so a lot of times I will answer something with, well, so here's what the law says so far, but the law is quite volatile, and so it could change. And so far, what has been considered incorporated are the examples I have here on this screen. So going through them, for example, so during the change of plea hearing, defendant's attorney stipulated the contents of a motion to set aside charges as the factual basis for a plea. So that motion to set aside charges was incorporated because the attorney said, okay, stipulate to those contents as the factual basis for the plea. And then another example, a defendant's counsel stipulated during plea colloquy that the police reports and other documents within the file contain a factual basis for the plea. So again, those words saying that incorporated the police report. And then during the guilty plea, a defendant said, I understand the court will review the certification for determination of probable cause in determining if there is a factual basis for this plea and sentencing. And that actually was considered incorporating the certification for determination of probable cause into the record of conviction. So it generally is looking at, I think the guilty plea and the plea colloquy is a huge place where things get incorporated. And so stipulating to anything or saying, this is the factual basis here, that's the thing that most of the time we see creating this incorporated situation. So then, what are general tips that defenders say that one should do? And of course, every jurisdiction is a little different. And so I really, rely on you guys over at the Office of the Public Defender to know what's realistic in your jurisdiction. But generally, not broadly stipulating that the police report or other court documents contain the factual basis for the plea, because if once you do that, the whole shebang is in. And so if you don't know exactly what every detail is in there, that can be kind of rather dangerous. For jurisdictions that allow it, waiving the reading of the facts during the plea colloquy, obscuring the facts by being as broad as possible. So following the elements of the statute of conviction is a very, very good advice, that if you need to have a factual plea, just essentially follow what the text of the statute says for this factual basis, if it's allowed. And then finally, allocating to safe harbor facts. So this can be a little tricky if you're kind of new to the area of the law and you're not really sure what a safe harbor fact is. But there are certain things that, if you actually do get it into the record of conviction, can make it really, really clear that your client was not convicted of this aggravated felony or this other thing. So that's another possibility. And then we use the term keep the record of conviction clean, be broad. So what is it actually that we're trying to keep it clean of? The identity of the controlled substance involved is one really big one. That the defendant used a firearm, or what firearm was used, because that would potentially invoke a firearm offense deportability ground if there's specifically mention a firearm when the statute doesn't require you to mention a firearm. And then, as we talked about earlier, that the victim was a minor, or that the victim was a spouse or other person protected under domestic violence laws. So keeping that out of the record of conviction. Okay, I think I just saw a chat come in, so I'm gonna see if, okay, so I can, okay, so the first question, do statements by clients and or their attorneys at sentencing get considered in the record of conviction? Yeah, so great question. Yes, there's been a lot of examples of that. And so during sentencing, that can be considered in the record of conviction as well. Let's see. Is it a problem that during the change of plea colloquy that the judge asks our clients, did your attorney discuss the state's evidence with you, including the relevant police reports? That's a really good question. So based on the case law that exists, that I've seen, I think probably not. That's probably okay. Just did the attorney discuss it with you is okay if you're not specifically stipulating to that as a factual basis. So I think probably not. There's not. I don't know of a case being particularly on point that would answer that particular question. But that's what I would think. A side note, Willie and I were talking about this a couple of weeks ago, actually, because he had brought up a question. And there is a student project that I would love for someone to take on, as actually to do some more research into record of conviction, and see what other examples are out there and really build our database of examples, even in other circuits, although of course those aren't so like Second Circuit, First Circuit, that's only persuasive. It's not law that, you know, a court under the Ninth Circuit would have to follow, but it's persuasive, and it can be, you know, sometimes the immigration judge here, knowing no other example, would just follow it. What are safe harbor facts? So an example is, so you're only convicted of aggravated felony fraud if the loss to the victim was $10,000 or more. I'm pretty sure that details it. It's $10,000 or more, but it's a dollar amount. And so if you allocate to the victim fraud to the victim being only like $10 or $100, you know, or some dollar less than that, that's considered a safe harbor fact. And yes, I will make this PowerPoint available to you afterwards. Thank you. Okay, all really, really good questions. Okay, one more question. In sentencing our clients, the judges rely on the pre-sentence report, which often includes a copy of the police report. Will that report be considered even though it is sealed? Or if the judge talks about the information they learned from having that police report be considered in a removal hearing? That's a good question too. The pre-sentence report is another one that's a tricky area of the law, and I've done some research on it, and I've still left with questions, honestly. And so thank you to volunteers for volunteering. Thank you for one volunteer who has volunteered to take on this research assignment. The answer generally, though, is not unless the defendant or the defendant's attorney has specifically agreed that the pre-sentence report is something that can be relied upon, either stipulating to it as a factual basis for something, or we're referencing it. Sentencing is also, again, kind of that whole process is a little bit trickier of an area too. Is it in the record of a conviction? Is it not? So it's actually such a good question that my answer is I think so, but the law is changing, and it's a little bit complicated, particularly in the Ninth Circuit. Okay, all right. I think that's it. I guess okay. Any other questions? Okay, awesome. Again, really, really good questions, everyone. I'm gonna jump into crime involving moral turpitude. It's probably, again, as I said in the beginning, the most common removability ground that you'll deal with and see. Essentially, every crime is at risk of being a crime involving moral turpitude. Every crime you have to ask yourself, is that a crime involving moral turpitude? And what makes it tricky is that the definition is not very clear. It's a very old definition, and it's essentially conduct that shocks the public conscience as inherently base, vile, or depraved, contrary to the rules of morality and the duties owed between man and man, either one's fellow man or society in general. It is a broad definition. It's also, I think, been whittled down in that things that one might consider inherently base, vile, depraved, that really makes you think of kind of the worst of crimes. And CIMTs, as we call them for short, are not necessarily the worst of the worst crimes. So a more specific general definition, it generally involves intent. So intent to defraud, to cause great bodily harm, or to permanently deprive an owner of property. So looking at the mens rea of a statute is really important in determining whether it's a CIMT or not. And these are kind of the big three things that'll be CIMTs: defraud, so any fraud cases, doing great bodily harm, or permanently depriving an owner of property. Sometimes, though, recklessness or lewd intent is also considered a CIMT, particularly if if it's reckless, but it finds that there's some other aggravating factor, then it'll still become a CIMT. So it doesn't necessarily require a knowingly or intentionally mens rea, but and I put here the Ninth Circuit puts out a guide on immigration, and they have a summary of different things that have been found to be a CIMT. So because I'm sending out this PowerPoint later, I included this link so you guys can look, because that's kind of the best way to figure out if something is a CIMT, see what's already been considered a CIMT. And so here's an example. So simple assault has been clearly found to be not a CIMT, but simple assault with an aggravating factor may be. And so what are these factors we're looking at? So the blue section, we're looking at mens rea. We're looking at, is this just offensive contact, kind of torts level offensive contact, no one's really getting hurt, or is it all the way to serious bodily harm? And another factor one might look at is anyone can be a victim, or the victim has a special relationship. So that's another aggravating factor. So here I create this little chart on the top, not CIMT, yes, CIMT. So basically look at your statute and see where on all of these spectrums, all these aggravating potential factors, does your particular statute lie? And again, we're looking at the statute, not looking at what the person actually did. And then compare it to a case in California that's found something to be a CIMT or not to be a CIMT. And that's basically the kind of research you have to do. And there's a lot of making analogies, a lot of comparisons, and a little bit of guesswork when it comes to it. And then how does a CIMT affect an immigrant? So you don't have to memorize this. I don't have it memorized. I look back to the statute every time, I want to double check something. Like I said, an aggravated felony is really just a single one and is very harmful. CIMT is a little bit different. It affects you different ways depending on when you came in, as in how recently you entered the US or were admitted to the US. Again, deportability versus inadmissibility, like I talked about at the beginning, it makes a difference. Then I included a link here that from a great organization, ILRC, that has a lot of great resources that goes into it more specifically. And then finally, I just wanted to touch on really briefly the circumstance-specific approach. I don't want to create too much confusion, especially for those who this is the first time they've ever learned about the categorical approach. There are some offenses where certain parts of the offense are analyzed using the circumstance-specific approach. That means that the immigration judge can go beyond the record of conviction. So for fraud or deceit, does the loss exceed $10,000? That's what I spoke about earlier as a safe harbor fact. So if you allocate that the loss was only $9,000, then that's a safe harbor fact. And in fact, the judge can go beyond the record of conviction to try to figure out if it is. And so if you already know it's 9,000, allocating to it right there in the record can be easier. Marijuana exception, there's marijuana exception, petty crime. So that's if it's 30 grams or less, there's a marijuana exception to the controlled substance offense. And then again, the crime of domestic violence is their domestic relationship. So that they can also go beyond the record of conviction. It still matters what you put in the record of conviction, because it's all about, a judge can go beyond the record of conviction, but sometimes it's hard to find. Also, a recent Supreme Court case found that for certain types of relief, it's the immigrant's job to prove that they were not convicted of an aggravated felony. And so another reason why this presentation is so important, and the role of defenders is so important, is that you're not guaranteed a lawyer in immigration court. And so for a lot of folks, their public defender is the only and last attorney they will ever talk to before they get deported. And so understanding and advising them and kind of putting them in their best position can make a huge difference once they get to immigration court by themselves. And so, but again, circumstance-specific approach, it only affects certain categories of crimes. Overall, it's all about the categorical approach, but did want to bring that up in case that came up and you guys were confused. Like Catherine said, we don't care about the facts. There's some cases where they can look into the facts. And finally, the law is changing all the time in the Ninth Circuit, at the Supreme Court, at the BIA level. And so, and that's just important to know too, because there are changes so often that, if you're looking at a case from 2008, very likely that's hugely outdated. You're looking at a case from 2016, it might be outdated. And so shepherdizing your cases all the time, kind of keeping up and not relying on, if you see on the internet, ILRC put out a great pro se guide from 2010. That's a great starting point, but know that law might have changed. So you kind of need to do some of that own research too.